Great. Okay.
I've been schooled on how to use the mic, and I'm going to really try to pay attention, but let me know if I'm too loud or too soft. My name is Donna, and I'm the Legal Justice Coordinator for the Women's Freedom Center. And we are absolutely delighted to bring you this community conversation tonight, which has been very intentionally crafted over many months by the Women's Freedom Center and the Women's Action Team. So each of us who are on the planning team is going to just have a moment to introduce ourselves, and just want to say the Women's Freedom Center has been in this community serving Windham County and Southern Windsor County for about 40 plus years, 45 years, is my coworker across the room. And we work with survivors of domestic and sexual violence. We have a 24-hour hotline. Our work is confidential. We are not mandated reporters. We do court advocacy, provide shelter, safety planning, and are available 24/7. We have many community partners with whom we work closely to try to provide safety for survivors and accountability for violent offenders. So we're thrilled to be here. It feels like a really important conversation for us to be having front and center in the main room of the library.
Hi. Am I on? No.
Here it is. Okay, it's working. So my name is Lisa Kuhneman, and I'm here with the Women's Action Team. The Women's Action Team is a feminist grassroots group that formed in the wake of the 2016 election, with the main focus being artful action in response to all the things going on. One of our action teams, the hashtag #MeTooTeam, has been engaged in various things that have since that time, and this is something of a culmination from that beginning. And there was a point where we were involved in action, and we realized, we need to approach the Women's Freedom Center, and learned a lot about what's going on there, the work they do, and decided that we also wanted to support the work of the Women's Freedom Center and collaborate further. So thank you for coming.
Hi, I'm Cass Pastorell, and I've been on the board of the Women's Freedom Center for about 3.5 years. And I first joined because I really just wanted to take action in the local community around issues I really cared about. And I had a personal connection to domestic violence. I'm an avowed feminist, and I just really wanted to get involved in a tangible way in this community. So just amazing work that's done there, and amazing people who do it. So I'm happy to be a part of this tonight.
Hi, I'm Diana Whitney, and I'm a founding member of the Women's Action Team. So happy to be here with all of you. And I was inspired and perhaps compelled by the subject that we're talking about as I started speaking out around the issues of Me Too, and found myself personally faced with legal action and the fear and vulnerability that brought. And so I found myself wanting to get some answers to these questions. And that's part of the catalyst for this Know Your Rights conversation. And also my understanding that having really excellent counsel is one of the best things that you can do. And I'm really lucky that my cousin, Mike Lewis, is one of our guest speakers, and he was there for me, and I'll have a lot of other guest speakers to help us with these questions tonight. So thanks.
Hi, I'm Willow Farrell. I'm a documentary filmmaker and also part of the Women's Action Team. And before I forget, there's childcare available. It doesn't look like there's any kids around, but if you brought any, there's some awesome male feminist allies in the children's room who are ready to look after your rugrats. Yeah, I think that's it. There's merch over there, t-shirts, and my DVD, Break the Silence, which features women in the community, so if you're interested.
So we have just a very brief opening that we borrowed from a group of gay male a cappella singers. Some of you may be familiar with the Flirtations. Before every concert that they do, they give the people who are coming to hear them a little bit of information about who they are and what their music means to them. So when we sat together, we decided that we would share some of our lived experience and name that right out into the room, just to create this canopy of safety for those of you who may want to take risks and ask honest questions into the room. So the exercise is called Some of Us, and we're going to stand shoulder to shoulder and share some of our experiences. We will not be naming necessarily our own lived experience, but the collective.
We don't need fancy. Okay. We practiced this for so long. Do you want to start us off? Yeah. Awesome. All of us. Oh, this is on. You have to talk.
All of us are truth tellers who speak out against rape culture and injustice.
Some of us are survivors of sexual assault.
5 of us are daughters of sexual abuse survivors.
1 of us knows that the rage and pain from trauma inflicted on the women in her family by the men in her family fuels her creative work and activism.
All of us are community organizers, artists, activists, and facilitators.
2 of our grandfathers beat our grandmothers.
Most of us have experienced sexual harassment multiple times.
2 of us focus primarily on systems and change.
1 of us has been called a liar for speaking publicly about a perpetrator.
1 of us grew up in a domestic violence household. Her mother went through the legal system. After 20 years in abusive marriage, her father served 2.5 years' time in prison.
All of us are focused on intersectionality and the relationships between various forms of oppression, including racism, classism, sexism, homophobia, transphobia, and ableism.
1 of us is the mother of 2 daughters she fears will face sexual violence.
1 of us has a father who admitted to her mother that he wanted to molest her as a child.
All of us envision and work to create a world free of gender harassment and sexual violence.
All of us are deeply committed to and welcoming of this conversation.
So we're going to welcome our speakers now. Oh, no. Oh, what's
Yeah.
Thanks. So I'm going to make an introduction, yeah. And I'm going to read. That's the way it works for me. So we're here today thanks to the phenomenon called #MeToo. This movement, founded by civil rights activist Tarana Burke in 2006, took the United States by surprise when an avalanche of survivors' stories of sexualized violence were suddenly gathered in one place in 2017, making it possible for all of us to realize that cultural assumptions about gender dynamics and interpersonal power have created a harrowing environment for anyone lower in the social hierarchy. We know that the Women's Freedom Center phone, the phone there rings constantly. Ms. Burke wanted survivors to know that they're not alone. Why? Because silencing survivors against their will is a secondary harm that has consequences of its own. And because isolating survivors perpetuates not only harm, but the cultural assumptions that normalize that harm and create complacency. We want to see a reduction in the incidence of sexual violence in our communities and a reduction of the harm and the fallout. We're here today because we believe our community can be a safe place for survivors to speak out publicly. But what does this mean for people who are called on to examine their behavior and for accountability? The behaviors we're talking about have long been considered criminal. Why hasn't criminalizing sexual aggression created the kind of reckoning that changes behavior and reduces harm. Tarana Burke points out that while survivors have gained much needed awareness and legitimacy to date, quote, the problem is we home in on the perpetrator and make these unnuanced decisions and rob ourselves of the opportunities for reckoning. Culture shift doesn't happen in the accusation. It doesn't happen in the disclosure. Culture shift happens in the public grappling with these questions. Today we hope to increase our awareness of civil law and how it works to encourage or discourage survivors who choose to speak publicly about their experience of sexual aggression or harassment. So we have some goals for our conversation. We invite you all to bring your experience forward and to leave the culture of the office behind. We invite you all to bring your experience, oh, I said that, sorry. We want everyone to be informed about the rules of civil law, but we also view the relationship between law and culture as a chicken and egg scenario. We may ask which comes first, culture change or legal trends, but the relationship between the two is dynamic with politics in the middle. This knowledge should empower us. There's a beautiful poster in the waiting room at the Women's Freedom Center's offices of American political activist, academic, and author Angela Davis with a quote that might inspire us. You have to act as if it's possible to radically transform the world, and you have to do it all the time. So we will hold space for conversation that we hope allows for and acknowledges a range of experience that any of us feeling empowered enough to join here today may not be able to imagine. Obviously, some of our subject matter may be upsetting. We invite people to take care of themselves, and if you decide you have to leave for any reason, don't worry about us. That's fine. We are going to send around 2 sign-up sheets in case you want to be informed after this with follow-up information, one for the Women's Freedom Center, one for the Women's Action Team. If they don't go around, we'll have them at the back table. We'll try to get those around. And we have cards on the floor with pens. We'll be taking questions in 2 ways. One, you'll be able to raise your hand and speak your question out loud if you'd like with the microphone. Or the other is you can write your question on a card and we'll pass a hat around. And we'll ask your question for you if you're either uncomfortable using the mic or you just would prefer somebody did that for you for any other reason. And in that process, we may offer a framing that hones big, broad questions a little bit in keeping with the focus of our conversation, and we appreciate your permission to do that. You can see the agenda behind us. We're going to hear from guest speakers. Then we're going to have a chance to find out who's in the room. That'll be brief. We are lucky enough to have a poem to share. And then from 7 o'clock, we'll begin with our process of asking questions and listening to answers. Okay, thanks.
Thanks so much, Lisa. It's great. So I'm going to just briefly welcome each of our speakers, starting with Cara Cookson, who's may have driven the farthest today. Thank you. Cara is a public policy director and victim assistance program coordinator for the Vermont Center for Crime Victim Services. So she's going to tell us a little bit about her work, and then we'll move on to all of our other speakers.
Hi there. I am from West Bolton, but lots of familiar faces in the room, which is really nice. So I'm actually now the former policy director of the Center for Crime Victim Services. I do some advising for them. I'm also on the faculty of Vermont Law School in their Restorative Justice program. I'll be teaching victim rights law and trauma, adversity, and victimization. So a little plug for VLS. It's for non-law students too. So, you'll also notice in my remarks that I tend to use the words victim and survivor back and forth and interchangeably. And that's because under state law and some federal laws, the word victim is a legal status. impart certain rights on individuals. And there are also some people who prefer to identify as victims, and there are some people who prefer to identify as survivors for a whole host of reasons that are personal to them. So in my work, I kind of go back and forth between the two. So for the past 3 years, it's been my job to go to the State House and advocate for the rights and needs of survivors here in Vermont, which has been a pretty weighty and intense experience, although in a place that tends to be reasonably friendly to the thoughts and concerns of that constituency, which has been really nice. I can deliver some good news from Montpelier, and that I think will be of interest to this group, and that is that last year the legislature passed a law that prohibits employment discrimination on the basis of, and again, this is a legal status, crime victim status, which might include someone who's reported a crime or is perceived to have reported a crime, or someone who has pursued one of the various protective orders that are available to people in Vermont. It also provides that someone who has that crime victim status is entitled to unpaid leave to participate in court process related to that. I think that Vermont has maybe the most comprehensive employment discrimination legislation for crime victims in the country at this point. We were sort of late to the game, but we caught up really fast, and we picked up from the experiences of a lot of other states. So I think that's an area of concern for a lot of survivors, and it was actually the impetus to really go after that was motivated by a young woman who in a different county who had reported a sexual assault that hadn't happened on the premises, doesn't matter, to one of her supervisors, and they ultimately terminated her because they thought that she might get distracted at work, and her name could get out in the press, and it could tarnish the good reputation of this wedding venue that makes these magical dreams come true. I'm being facetious. But anyway, so, you know, that, and what we learn in kind of digging deeper is that that's really not uncommon. And it's even more common maybe in an environment where a survivor and somebody responsible for harming them are working in the same premises, and maybe you know, they prefer to keep the chef over the waitress, or who knows. You know, there's a lot of scenarios like that we've learned about that happen in Vermont. So we're hoping to do more to spread the word about this law and see it effectively enforced. So I can answer more questions about that. Thanks.
Thank you so much. So we have Michael Lewis, who joins us from Concord, New Hampshire, where he works for the firm of Rath, Young, Pignatelli. And Michael is a First Amendment attorney and litigates a range of matters involving state, federal, constitutional rights, areas of free speech, and social media.
So, thank you for welcoming me here to Vermont. I actually share a background with Cara to a certain extent. I was a homicide prosecutor for 6 years, and I have lots of experience speaking up for victims in public fora. And it's certainly true that the recent era has been one flourishing in a very healthy way, as against the silencing that has gone on for centuries against people who have been victimized as marginal people in society, and that is an incredibly healthy thing. And it's something that, as a lawyer, I try to go out of my way to support. And one of the very wonderful things about Vermont, your jurisdiction, is that you have a very, very speech-friendly series of laws. And what I'd like to talk to you a little bit about is the practicalities of being on the receiving end of a legal threat that will threaten to silence you as you go through the process of attempting to speak your mind about matters of public importance. Because that can be a very, very scary thing for a non-lawyer. a threatened litigation is terrifying. And if you find yourself in a position where you have spoken your mind and someone has sent you a letter, and the letter threatens a lawsuit, that could be paralyzing. But the reality is it shouldn't be, and you should feel like you have a series of very important and helpful legal mechanisms at your disposal that you can use to react against to protect your free speech rights. Fundamentally, what Vermont has, which a lot of other jurisdictions does not have, is what's called an anti-SLAPP statute. It's contained at 12 Vermont statute, annotated 1041. And what an anti-SLAPP statute does is it flips the script in a scenario where there's been a demand made for defamation damages, false light damages, some sort of threat of a lawsuit as against someone's free speech rights. Now, in most situations, in jurisdictions that don't have this type of statute, what happens is that a person has to imagine bearing the cost of defending against a litigation like this. And that could be very expensive. You get sued, you have to answer, you have to go through depositions. That could be potentially very expensive for someone. What Vermont says is, nope, the first thing we're going to do is measure whether the person who has been sued has a meritorious First Amendment defense. We're going to accelerate the free speech, free press inquiry, put it at the very beginning of litigation. And they do it through what's called a motion to strike process. So you get a demand letter and maybe you get a complaint and it's been filed against you. You have the opportunity to file what's called a motion to strike. And you put the First Amendment right front and center in the litigation. If you win, you get your attorney's fees. So it not only flips the script, but it flips the financial risk. And so that's a very unique and important, not very unique, but it's unique to Vermont and Northern New England. It's an important thing to be aware of, and it's an important antidote to your fear should you speak and be on the receiving end of a demand, okay? And Vermont lawyers, I'm not licensed to practice in Vermont, but my law firm is. There are going to be Vermont lawyers who are going to be extremely well-versed in this area. You also have an ACLU branch. If you get a demand letter, you should be thinking about, okay, I feel as if this lawsuit is going to suppress, some sort of free speech, free press right. Google your ACLU chapter, call them, and see if they have resources, local or state, that can assist you in thinking about a defense. Now I'm going to get even more practical, okay? Which is, and this may be more specific to the writers in the room, but it may be general as well. It's going to sound so boring, but it's still important. Ultimately, what a lawsuit is attempting to do is it's attempting to get at your money and your property, because lawsuits cannot, under constitutional law, on the front end, enjoin you from speaking. That's called a prior restraint. If someone sends you a lawsuit and they say cease and desist, and we're going to enjoin you, we're going to get an injunction silencing you, that is immediately going to be stricken as unconstitutional. It's not going to survive. What they're trying to do is get your money. They're trying to threaten to get your money. And not a lot of people are rich enough to support a kind of lawsuit on their own, but you may have more at your disposal in terms of assets to draw on in order to defend. Lots of people are insured. And one of the things that is fascinating is, like, you have these insurance policies, but you rarely call upon them. Some of them may have coverage, you can Google it, that will cover the defense of this type of litigation. Umbrella insurance, if you Google it, will. If you're a writer, you should think about getting it. Because if you're a writer in a controversial area, and you enter a forum and you want to speak freely, and you want to make sure that you have a lawyer ultimately assigned that will be paid for, you may be able to get insurance that will provide that. It sounds super boring, but it's still a way of making yourself feel more comfortable about entering the First Amendment domain, speaking freely, and knowing that You won't face some sort of black hole bankruptcy litigation situation that will paralyze you and put your life and finances at risk. So, these are things that they're very gritty, practical, they're about the legal system, but you should be thinking about them as Vermonters as you imagine, participating in the area of free speech. The other thing you need to think about is the reality is you have two layers of constitutional protection. You have the federal Constitution and the state Constitution. And we all know that the federal Constitution is largely in the hands of the U.S. Supreme Court, and we're not sure so much how sympathetic the U.S. Supreme Court is going to be around speech issues going forward. We're just not sure. There's a lot of flux around that. But that's not the end of the game. It's not even the beginning of the game. The beginning of the game is that before the federal Constitution was even ratified, Vermont had its own state constitution. Inside the state constitution, it had independent free speech and press rights. And those rights are going to be more expansive, at least as expansive as the First Amendment, probably more so. They are in New Hampshire. And so one of the things to remember is that anytime you're facing a threat of a lawsuit to suppress your speech rights, you have multiple layers of legal protection, statutory, state, and federal constitutional, at your disposal to protect yourself. Now, the final thing I would say is, and this goes to how we speak to each other, how respectful we are, and how thoughtful we are inside a public forum. The best defense against a lawsuit is going to be the truth. And being able to reflect on what comes out of your mouth, what is produced and generated at the tip of your fingers as you type, researching, being thoughtful and deep is not only beneficial to the quality of public discourse, but it is beneficial as a defense. And the more factual you want to be about your critique, the more you should be thinking about backing up the facts you want to inject into public forum with research and real data. And because truth, ultimately, in a defamation case, which is the most popular way to use a lawsuit to suppress speech, is a defense. So being able to marshal the truth is an incredibly powerful way of defending against a lawsuit. And so that's some self-help. And it's not stuff that is, that final thing is something you can do for yourself that doesn't require a lawyer, that just is about being a careful and thoughtful speaker in an era where that is deteriorating. And, I think we have an obligation, when we're engaging in free speech to make sure that we're fighting against that through, the depth with which we think through what we say. So anyway, I'm sorry, I went on. I just wanted to. So thank you very much for your time.
Thank you, Mike. That was great. I'm going to go home and get that insurance policy. Next we have James Valente, a native of Marlborough, Vermont, now the managing partner of Costello, Valente, and Gentry, and he concentrates his practice on civil, criminal, and family litigation. Welcome, James.
Thanks. Am I going through my whole little spiel now? Or?
Yeah, that's
okay.
your spiel.
So I do a variety of different kinds of trial law, which means I go up in the courtroom for a contested issue, and sometimes I talk to the jury, sometimes I talk to the judge, oftentimes we never get there. I have cases sometimes against other local lawyers in the room, and sometimes I find myself on the other side of Donna in the family court. And I've done a little bit of everything. I've represented a couple of dogs here and there, but that's not a joke either. It's extremely rare to have a defamation case go to trial. And I have defended a defamation case all the way through to a jury trial, really just through dumb luck that created circumstances where two people on either side could pay for the imposition of the trial. On both of them. And my goal is to give you the fastest version of what they would teach in law school so you understand how defamation works and the burdens of proof and that sort of thing. I suppose I should disclose that I did not go to law school, so this is a little bit of an odd version. I apprenticed, like Lincoln and those folks do, but also not a joke. So defamation is something that it can describe libel, it can describe slander. It is fundamentally when you publish an untrue statement against someone else that causes them damage. If you wanted to distill it down to one sentence, that would be the sentence. But there are a few things to understand about defamation. One is that the law on defamation is very poorly developed. We follow the British system that's been around since the Magna Carta, where there are written laws, statutes, and there are things that the Supreme Court does called precedent, and both of them establish the authority that we live by. Defamation suits are incredibly uncommon. I could not find in any New England state a defamation case related to sexual harassment allegations. I looked in Maine, New Hampshire, Massachusetts, and Vermont. That means none has been appealed to the Supreme Court. It doesn't mean it's not happening. It just means that there's no Supreme Court that has said, okay, this is how you ought to deal with this. Most of the defamation law in Vermont is set forth in 4 Supreme Court cases in the last 30 years. And it deals with accusations of people being a thief. One of the cases is about unscrupulously selling copying machines in Rutland in like 1984. And so sometimes the Supreme Court gives us lawyers a very clearly defined framework. Sometimes the United States Supreme Court gives us a very clearly defined framework. But when it comes to defamation, what I'm giving you is something that is not designed to suit claims like I was sexually harassed or sexually assaulted by this person. It's something that really was developed in a different time when, quite frankly, the idea of the Me Too movement was antithetical to the things that the court system dealt with. And I expect that specific questions may be unanswerable on how the thing we're here to deal with tonight should be dealt with under defamation law for another decade. I don't know if you disagree with me on that, but so pardon me if some of this sounds a little bit unrelated. This is the framework when we do question and answer. I'm going to try to relate your questions to. The defamation burden of proof is unique. When somebody sues you for defamation, the first thing they have to do is prove that you're lying. They have to meet that burden of proof. Then you get a burden of proof. You can prove that what you were saying was true. That doesn't sound like it makes any sense. This is what's called an affirmative defense, the defense of truth. I think everybody has probably heard, well, truth is a defense to defamation. And this is the mechanics of how it works. A person who is prosecuting you, who's suing you for defamation, can give enough evidence to show that you're lying. But you can then offer your own evidence showing that what you were doing was truthful. So they survive kind of round 1, and then you get round 2 to say, actually, here's my evidence to back up what I said. Here's a corroborating witness. Here's a document that supports it. There's all sorts of different forms. And that defense, if you can establish it, is dispositive. But if you can't establish it, that's not even the beginning of the end of how a defamation suit works. If you can't meet your burden of proof and show that it was true, you haven't lost your case. I'm sorry, I prepared about 40 minutes worth of stuff to put in 5 minutes. There are a variety of situations where the person suing you has to prove other things. The first is that you've published your statement. And a lot of people think of publishing, they think of books, newspapers, magazines. In this arena, though, publishing is saying to any third party the thing that is false. So if I lean over and I say, hey, let me tell you about this thing about John that John did, and it's false, and I know it's false, I've just published that statement. Sorry, Michael. I don't know why I thought his name was John. It's because his dad's name is John. But so I have published that, and if John finds out that I've published this false statement, just anybody in this room, even if it's on the newspaper, even if it's not in the magazine, even if it's not on the radio, he can meet the burden for publication. So that's the first thing he's got to do. The next thing is show either I knew it was false, or I should have known it was false, or I didn't make a reasonable attempt to ascertain whether or not it was true or false. The first one of those is very simple. If you know it's false, you know it's false. The second one is pretty complicated because the line at which point someone should know something is false can be very difficult to draw. However, because we're here to talk about speaking about your own allegations of being abused, assaulted, harassed sexually, because if you're making those statements, you're likely the only person who could know, that complication doesn't really matter. You will know either it's true or it's false. The third factor doesn't really apply either. That's meant to deal with newspapers, magazines, radio, etc., who might republish your statement. So if the New York Times publishes a story, or the New Yorker, publishes a story summarizing a series of allegations, and they make no attempt to actually verify that information, then they could be on the hook for defamation because they're publishing in a different way. After you get through that, if you establish that a person not only is lying but knew that it was a lie, then there are a series of privileges. There's something called the common interest privilege, where when you make a statement where you reasonably believe that you're sharing information with someone who has a common interest in the subject matter. This is an area that really was meant to deal with business relationships. That's where the privilege comes from. I think that the fact that we are here together in this room discussing this indicates that there can be a very non-business common interest in a subject matter like this. Nobody's here to make money. And this is one of the things that I would expect could be resolved through case law in the future. Like if we're in a meeting like this and somebody discloses, okay, here's what's happening because they have a common interest in addressing this type of thing, do you get that privilege or do you not get the privilege? I don't know because there is no authority saying you do or you don't. And we're in a non-traditional common interest relationship. But when there is a privilege, it protects you. And the person asserting defamation has to show malice. Everyone knows about a lot of people know about the privilege when you're speaking about a famous person. You know, if I wanted to make a statement about Donald Trump or Phil Scott or some other famous person, they have to show that I'm doing that maliciously, even if I knew it was false. The common interest privilege works the same way. It's just like the privilege that applies to speaking about famous people. And so when you are speaking in a common interest relationship, you have a kind of a little protective zone the same way you would if you were speaking about a public figure. I should, though, throw in the disclaimer that the common interest privilege has never been recognized in Vermont. It's never been not recognized. It's never even been taken up. There's a second privilege, and it works exactly the same way. It's the same style privilege that you would enjoy if you were speaking about a famous person or a matter of public interest. And that's a response to a question. It's an interesting dynamic here, but the way I imagined it coming up here is if perhaps there was some knowledge in the community about a person who had perpetrated multiple improper sexual acts, and someone asked you, were you ever approached by this person? Were you ever propositioned by this person when you worked for them? And you were responding to that question. At least under the common law, that enjoys the same level of protection if you're speaking about a famous person or the common interest thing that I just described. You need to show malice. And this has the same disclaimer that I offered with the other exception. It's never really been discussed in Vermont. There was a single case I found from 1985 where a credit reporting agency, in response to someone asking for a credit report, incorrectly said that someone claimed bankruptcy. And the Supreme Court said, no, that's not answering a question. You guys have a higher obligation. But the reasoning was completely different than the kind of reasoning we would try to apply to the scenario I just described. So I don't think that that should be persuasive or dissuasive of the privilege applying to answering a question. In my view, where there's no authority, all we can do is look at the common law, and the common law says it's there. So once you're through all that, the person claiming that there's been defamation has to show that the defamation harmed them. It's not enough that it's false. It's not enough that you knew it was false. It's not enough that you published it. They need to also show that it actually harmed them. They can do this fairly easily if they lose a job or if they lose contracts. Those are kind of black and white. But they can also assert as actual harm embarrassment, and I'm reading from Vermont case law now. Embarrassment, personal humiliation, mental anguish, loss of reputation or standing in the community. Because of the nature of anything sexual in a statement, I actually think that this is one element that would be fairly easy for somebody who's asserting defamation related to this to get over. So if they get over the first 4 or 5 hurdles I've described, if they can show that it was a false statement or a false allegation of sexual harassment or something like that, it's pretty natural that embarrassment would follow. The standards are different for written statements and oral statements here. I don't like to get into libel versus slander because it really doesn't matter under defamation law except in this one circumstance. When a defamatory statement is written, if we get over all the other hurdles, it's false, you knew it was false, you published it. If it's written, it's assumed that there are damages. And the only question for a jury is how much. If it's verbal, damages are not assumed. The person who's saying they were damaged has to prove that. Except under 4 circumstances, and these go back maybe 400 years, accusations of a crime. It's an interesting question if what you're accusing somebody of falls short of the legal definition of sexual assault, whether claiming, for instance, you were groped is an accusation of a crime, because it's an open question in Vermont if it's a crime to grope somebody, and that's a whole other kettle of fish that I can get into, but I can't do it quickly. Statements that hurt your business, that's one of the other verbal pieces of slander where they assume damages. Charges of having a loathsome disease is one of them, and unfortunately that could actually be relevant to these types of claims because some things go hand in hand. And the last one doesn't matter at all, but I thought it would be somewhat amusing given my audience. The only other one where damages are assumed are allegations that a woman is unchaste. That's your last slander per se.
We used to be there, that is imputation of unchastity to a woman.
Yeah.
It's a separate category.
And that's still in the books?
It's part of common law.
It's not in the books. It's in decisions that date back hundreds of years, and there have been no authoritative decisions saying, no, that's not the law anymore, but that doesn't mean it's still the law. That gets very complicated. I would not be surprised. It really depends on the facts of the case. I mean, if someone did publish a knowingly false statement that a woman in the community was unfaithful to her husband and something bad happened to that person as a consequence, and she sued, I would think that it would be unlikely that a court would say, well, you can't sue. On the other hand, I could imagine that there would be circumstances where a Supreme Court would say this is clearly archaic law that shouldn't apply anymore. The last thing I wanted to talk about is specific damages. I could only find one case in Vermont with specific damages for defamation, and that was a case called Cooper from 2007. But every single case here where there were situations where someone very clearly said something like this person is a thief or a liar that resulted in them losing their job or business contracts. And on the question of what a defamation case is worth, I sue people for money somewhat frequently, and I'm always trying to figure out what cases are worth. I look around at verdicts in other areas to try to do that. This is so hard to determine because of the lack of verdicts. There are $1 million verdicts from other jurisdictions, but it's the Wild West as far as what a defamation claim would be worth if it were successful. But the long and the short of what I'm trying to describe by going through the process here is that it's a lot harder to win a defamation suit than I think some people appreciate. There's a lot of burdens you need to get over in order to get a verdict. And in the case that I defended the person who was accused of defamation. I think the jury came back in about 15 minutes and came in with a defendant's verdict. I also do plaintiff's work. I don't think I would ever take a defamation case if it wasn't clearly in writing and with some clear documentary evidence that it was false, a way to prove the falsity. So just for information.
Thank you so much. Very interesting. So we're going to move on from our attorneys. Actually, let's do Deborah next. Or no? Yeah? Okay. I had you guys. Mel's next. All right. I had it in a different order in my thing. So Mel Motel, Executive Director of the Brattleboro Community Justice Center, and she's been the director since August of 2017 and worked in restorative justice, social justice, and education. So thank you.
Thanks for having me. I was thrilled to be asked by Lisa to be here, both as a representative of the Brattleboro Community Justice Center and restorative justice communities throughout the state. But I'm also glad to be here and be part of this conversation because I am a woman. And in my communities of women, there is not a single one of us that has not been touched by gendered, sexual harassment, domestic violence, sexual violence, one of those things. So this is something that I think about every day as a human in my community, and not just as something that we do for work here in Brattleboro and throughout Vermont. So I'm bringing all that with me as I do a little spiel right now, and I'm looking forward to the conversation that comes out of it. One of the reasons Lisa talked to me, I think, is because there have been a lot of questions about how does restorative justice relate to cases of sexual and domestic violence in Vermont. So I'm going to speak to that a little bit. I'm going to speak to what we do at the Brattleboro Community Justice Center, which is right next door in the town building. I'm going to talk a little bit about what we don't do, and I'm going to talk a little bit about what the possibilities are. So first of all, at the BCJC, the Brattleboro Community Justice Center, we offer restorative justice programs, practices, and processes for people throughout the community. We have a staff of 3 and a volunteer base of 50. So most of these processes are carried out by regular people in the community. You'll find us in an elementary school helping to mediate a playground conflict. You'll find us in neighborhoods helping people who live in a low-income neighborhood figure out how to solve problems on their own without the help of outside intervention. You will find us working with people in our office who have been referred to us through the police, the state's attorney, probation and parole, around offenses from driving drunk to retail theft, and including people who are coming out of prison after many years of incarceration, in some cases because of committing sexual and domestic violence. So I want to be very clear. We do work with people who have been convicted of these crimes, but we do not bring people together around these crimes. So I want to be very clear about that. So at the Brattleboro Community Justice Center and at community justice centers more broadly, there are 20 of us throughout the state. We do not get cases referred to us around domestic and sexual violence. And there's a couple reasons that I want to share this. One is because it's a matter of statutes. We just simply do not get those cases. But the reason for that, I think, is related to the reason that I would not accept a case right now anyway, which is because I don't think that staff at our community justice center and our base of 50 volunteers have the skills and have the training and understanding to deal with the complexities and nuances of sexual and domestic violence. These cases are very different than even some of the interpersonal violence we see when people get into a bar fight, or someone yells at their neighbor after knocking their car into their mailbox. These are very difficult and specific dynamics that we would really need our base to be able to hold if we were to do any kind of restorative process, and we're not there. So we don't take these cases. However, I want to share 2 timely things. One is that there's an Act 146 study committee. Is anyone in here on that study committee? Oh, great, okay. I won't put you on the spot.
Please don't.
I won't. I'm sorry I even asked, and I'm like looking at Kara as if it's probably you.
I sent her.
Oh, okay. Okay, don't even put the camera that way. So there are people in this room who could speak to this in a more educated way than me, but I will say that there has been a group of survivor advocates, victim advocates, people in the restorative justice field throughout the state who has been gathering throughout the last 6 months or a year to discuss whether restorative justice is possible in this state for cases of domestic and sexual violence. And my understanding is that group is still convening. They have released some sort of preliminary consensus that they have come up with, including the idea that restorative justice should be an option for survivors. Not that they need to do it, but that it should be available. And this is a conversation that's happening, and I don't think there's been any definite decisions on that yet, but these are some of the consensuses that are emerging. Right now, our system of restorative justice in the state is very much driven by perpetrators. It is very much about the person who did the harm, whether, again, that was someone that backed into a mailbox or someone that sexually assaulted his stepdaughter. It is about that person, and the referring agencies often have that person in mind. And so I think what this group is talking about is, can we have a survivor-centered restorative approach? And believe me, restorative practices, when done well, is survivor-centered. It is about the person who did the harm, the person who was harmed, and about the community that was impacted. So when we're doing it well, survivors are at the center, and we need to do better as a state. I'm hoping this is going to get us there. And one more thing I want to say is that even though we are not doing this through community justice centers, this, meaning restorative justice around crimes of sexual and domestic violence, is being done in other places. And I want to be really clear too, when I say restorative justice, I think often there's this classical idea of, well, it's about bringing together two people to have a conversation. Sometimes that happens, but really restorative justice is about asking who was harmed and how, instead of what rule was broken or what law was broken. It's about the people. It's about asking what the needs are of the people who did the harm, the people who were harmed in the community. And it's about engaging those people and figuring out what to do next. That does not mean bringing people together. I want to be very clear. Sometimes it does, if it's safe, if it makes sense, but I want us to challenge this idea that we might have that restorative justice means we put two people in a room together. That is not usually the outcome, actually. So there are groups throughout the country and throughout the world that are using these principles to work with perpetrators and survivors. There are numerous examples of grassroots groups and organizations who have a model of a support team and an accountability team, where there's a group of people who work with the survivor and a group of people who work with the perpetrator, parallel, for months, for years, working to hold the perpetrator accountable, getting them to take responsibility, and figuring out what the survivor needs, and those two teams communicating with each other. And if it makes sense and if it's safe, maybe those people will come together. So I just share that to say that even though in Vermont and the community justice centers, we are not at a level to be doing that right now for various reasons, it is being done, and it can be done, I think, with the right support and understanding, and making sure that survivors are centered at the process, or throughout the process. So that's my spiel, and I'm super happy to answer any questions, and really excited to hear what comes out of this conversation.
Great. Thank you so much, Mom. So Deborah Lee Luskin is a writer, public speaker, and an educator who lives in Williamsville, Vermont. She tells stories to create change through her weekly blog and through her published writing, and she leads workshops and writing circles throughout the region. Welcome, Deborah.
Thank you. So, I am a storyteller, and I'm going to tell you a story which you may be familiar with from reading the Commons. When, so much easier to write behind a computer screen. So, when Christine Blasey Ford was about to testify in front of the Senate Judiciary Committee, I heard someone say, well, why did she wait 36 years? And that was the trigger. Because I've been silent for 50, but for 12 years, I've been a commentator on Vermont Public Radio. And I was outraged at this comment about Ford because there's no incentive to speak out in the public forum. There are only disincentives. Naively, I thought, I've got this great relationship with VPR. I've been a commentator. They've hired me to do special projects. They call me up when they need a commentary on something that might be in my barnyard. And so I submitted a piece about why I waited 50 years. And I was told that I could not name my grandfather as I couldn't say that I'd been abused by my grandfather. I had to say, the first suggestion, you'll love this, was beloved male relative. And I am a very lucky woman. I have many, many beloved male relatives who have not abused me. Just one. And for 12 years, I had learned to sanitize my work. And I was so eager to be on the radio, I did. But I wasn't going to sanitize this. And it started what turned into a 10-day email conversation. And my agent in New York had told me, dead people can't sue for defamation. I didn't go to a lawyer. I believed her. And that didn't wash. The other thing, during this 10 days, Connie Chung wrote a piece that was published in the Washington Post naming her family doctor as having actually assaulted her during a medical consultation, and she was pretty graphic. And I thought, gee, VPR should be pretty glad I wasn't graphic. And they wanted my piece, but we came to loggerheads. They would not let me say grandfather, and I wouldn't say anything else. There's a really good, I'm a word person. This is the one word in the English language that describes this relationship, and it's an important relationship. I should say that what bothered me, and still bothers me more than the abuse, which I've compartmentalized and lived with, and continue to deal with, because it was triggered by this situation with VPR, where they never offered to go through a lawyer. They said, oh, this raises ethical issues, this commentaries come out of the newsroom. They said, if you say grandfather, we're going to have to do some research, and I had signed a contract that said I'm responsible for my content. So I didn't understand this. And I didn't really understand that I was being abused again until my producer asked me a series of questions like, have you told anybody about this? Have you ever been in therapy for this? Are any of your grandmothers alive? And then, is there anyone who might hear this who knew your grandfather? And it took me a while to wake up. My grandfather died in 1972. The only people he knew in Vermont were his son and my uncle. And they don't live in Vermont anymore. And I just thought that was pretty far-fetched. And that's when I woke up and I said, this is going to happen. And I called Jeff Potter. And what's really significant is that the first thing Jeff said, which was something that the producer I worked with for 12 years said on day 9 of our email exchange. Day 9, 3/4 of the way through an email, she said, first of all, and I should have said this, oh, and it goes without saying, as she says, first of all, and it goes without saying, I'm so sorry this happened to you. That was day 9, 3/4 of the way through an email. But I called Jeff and he said, I'm so sorry this happened to you. And he said, this sounds like something we can run. And I sent him the VPR piece, which was a 2.5 minute, 275 word piece. And then I woke up in the middle of the night, well, at 3 in the morning, and I wrote a 1,500 word piece about what happened with VPR, because for me, that was now the salient story. And Jeff said, this is fine, but if you will feel more comfortable, we'll send it to our First Amendment lawyer. And I said, yeah, let's do that. and the lawyer wrote back saying, it was a very moving piece and it's fine. And then I said to Jeff, well, did he say anything about what I've said about VPR? And he goes, I'll send it back. And the lawyer wrote back and saying, if what she says is true, and I'm assuming that she has her emails, it is good to go. And so it appeared in the newspaper. What was quite amazing and overwhelming was the outpouring that continues. But what's really disturbing and enlightening are the number of people who've come to me and said, me too. They said, it was my favorite uncle. It was my father's best friend. A couple of men told me. Happened to them. And I don't know if I know anyone, as Mel said, I don't know if I know any woman who has not been somehow endangered and have boundaries crossed because someone else thought that they could do that. But this issue of familial sexual abuse is a really big secret that has to be brought into the sunlight. I'm very grateful to the very beautiful actresses who spoke it out against what happens in Hollywood. But there are some of us who live in a different sphere where this is even more common. We're not glamorous, but that doesn't change the shame. I've not done anything to, my legal story has been told. And I'm very grateful that the Commons does have this legal counsel that they can refer to. There is a coda to this. I had an email from Ann Gallagher at VT Digger asking me if she could run the VPR piece. And I sent it to her. And she said, which grandfather? And I said, does it matter? well, in fairness to the dead as well as the living, and I just said, don't publish it. Both my other grandfather died in 1956, and I wanted to protect the living. I felt like the dead had their chance. So VPR said grandfather was too specific, and VT Digger said grandfather was not specific enough. And essentially, they've tried very hard to silence me. They haven't. I transferred all my support from VPR to the Commons. I am sorry that my story did not go statewide to an audience that used to listen to me. And I'm really grateful for the support that I've had from my readership. It is hard to do. And it's good. It's also really good.
Thank you so much.
Can I say one thing in response?
How long was it?
Very short.
Okay.
It's about legal definition. Okay, so
Thank you for that amazing testimony. When I listen to you and I reflect on the Blasey Ford Kavanaugh hearings and about the coverage, I'm a lawyer and I'm a former federal clerk and I care deeply about the rule of law. One of the things I think it's important for people to understand is that your narrative is evidence. So when people say there is no evidence that someone like Blasey Ford came forward with a credible narrative about what happened to her, that is false, okay? That is a false and deeply distortive characterization of what constitutes evidence. Your memory of what happened to you is evidence, and it's very important. And anyone who ever says to you that it's not credible or important doesn't understand what evidence actually is, okay? So, I mean, and I've heard it repeatedly, and that's my reflection, among other things, in response to what you said. People should understand that.
Thank you.
So we're going to, I believe, have a beautiful offering of a poem, and Lisa's going to introduce the poet. I want to just echo Diana's gratitude for each one of our amazing speakers. It's really powerful to hear each and every one of you. So we'll have this poem, and then we will be taking your questions.
So I'm going to introduce Shauna Kartha. She's a traveler, educator, poet, and short story writer. She graduated from SIT before going on to teach at the University of Missouri, Kansas City, and present readings and workshops in Latin America, Europe, and the US. She's writer-in-residence at Westchester Community College, New York, since 2016. Her books of poetry and short stories have earned national and international recognition, including the 2015 International Book Award for Poetry, honorable mention for the Best Book of Poetry in Spanish in the 2015 International Latino Book Awards. I did not attempt to read the award that's written in Spanish. She's named #1 of the top 10 new Latino authors to watch and read by LatinoStories.com, among many other things. I had a bit of serendipity. Shauna was coming to town today, arriving at 6 o'clock. We met years ago in Brattleboro and collaborated on a workshop for girls called, I was just telling Donna the name of the project, and it just left my mind. Anyway,
Espresso, thank you.
Yeah. What was it?
Espresso.
No, not espresso, but anyway, after espresso, and it was focusing on poetry and photography. It was amazing. We filled windows on Main Street with the photography and poetry of girls who did the workshop. So it happens that Shauna's here to tell us about a poem from a book that's being translated to English now. Do you want to introduce the poem?
Sure.
Buenas tardes. So, all my books except this one are published both in English and Spanish. My first books I translated myself, but finally I have a wonderful translator who takes care of that, because translating a book is rewriting the book again. This is a very special book. It's called Lágrima Roja, Red Tear, and it's in honor and trying to spread the word about what's going on in Mexico with women being disappeared, not just in the border in Juarez, but in my state in Veracruz. I'm from the Gulf Coast, Veracruz. And it happened that my connection with Vermont is that this is my first home when I came to the US. So it's very special, and it's true. I was coming to town at 6 o'clock, so that is just beautiful coincidence. And I lived here and wrote a few books here at Lisa's home. And this book has a special story. It was very hard for me to write. When I went back to Mexico after many years, I realized how violence has increased. And it was not just happening in the border, it was happening in my hometown, Jalapa, where I'm originally from. Many women are disappeared, many women are abused, men too, and I didn't want their names to be forgotten. I don't have their names here, but this is for them. So when I wrote the book, which took me tears and lots of time to process what I was writing, I wanted to focus on. So I sent the manuscript here without being translated to a couple of presses, and it was rejected. Then I sent it to Spain, to a press in Spain. After 3 days, they emailed me back, and they published it. So finally, not in 3 days, but after 3 days, I got a response. So now it's in the process of being translated. I have the poem translated here, the one I'm going to share with you. And so I'm just going to go ahead and read it. Niña sin nombre, girl without name. Golpe certero en el pecho, una víctima más, niña sin nombre. Hijas arrebatadas de los caminos, gimes en la penumbra por el abuso de tu cuerpo. Niña sin nombre en las calles adoquinadas. La inocencia fue lluvia, tu carne lacerada por el viento, tus entrañas desgarradas. ¿Quién impide hacerte justicia? ¿Quién impide tu curación? Se escurren las lágrimas silenciosas, llenas de sangre. Se desbordan los ríos color carmín. Cubren las calles, cuántas anónimas voces. Girl with no name. Direct blow to the chest. One more victim. Girl with no name. Daughters snatched off the streets. You moan in the shadows. Your body abused. Girl with no name. On cobblestone corners. Innocence became rain. Your flesh is slashed by wind. Your entrails torn asunder. Who stops justice? Who stops your healing? Silent tears of blood slipping down. Carmine color rivers slip their banks. They fill the streets. So many anonymous voices. Just one. So after this was published in Spain, incredibly enough, last year it received the first place as Best Book of Poetry in Spanish for the International Latino Book Award. Someone was listening and reading. Yes. Thank you.
It was called Girl's Eye View, that project that we did together. Thank you. So we're going to pass the hat.
We're going to pass the hat, not for contributions, but for those of you who would like to write your questions on a card and have them read into the room anonymously. At this time, we also will invite questions directly asked of anyone who has spoken. And I also want to say there are many, many people in the room who are community partners who are working every single day with survivors in different capacities. So we're just going to have a moment of acknowledgement about that.
Can we ask questions? Yeah. Okay.
So we invite you to raise your hand if you work for the legal system. In the legal system. Okay. If you work to empower survivors. If you've been affected by the Me Too movement in some way. If you're just curious and want to know more. Right. If you want to do something but you don't know what to do. Yeah. And if this is a local issue for you. Thank you. So we have a question?
Oh, me, okay.
So I have two questions. One is kind of two-part. One is sort of the glaring question, what is adequate proof? And is it possible to, what do they need in order to prove a claim false? Is it just enough to say there's not enough evidence, or do they actually have to have some kind of evidence that proves the testimony of an individual false? And then the other part was about crossing state lines, about making accusations across state lines and which laws protect or don't protect. I was asking the lawyers, I'm sorry.
Yeah.
Okay, so the question of what constitutes proof is a really complicated one. And the more cases you try, in a way, the more confusing it becomes, because we have a jury system. If this was a case in the civil courthouse, we'd go up to Newfane and there would be a pool of about 50 jurors. Each lawyer would ask them questions designed to try to weed out people who are prejudiced, but of course, you don't usually get jurors who raise their hand and say, well, I'm sexist, so, take me off the jury. And it's very tricky. I, for instance, defended an African-American person in a criminal action here, and trying to figure out how you're going to ask questions to the jury to suss that out is really complicated. And then juror deliberation is confidential. No one really knows why you win. Speaking from a lawyer's perspective, you don't often know why you win a case or why you lose a case. Sometimes you go out and you try to reach out to jurors afterwards to figure that out. But there are times when I have won cases and I thought to myself, well, I think I know why I won that. And then you kind of move on to the next thing. The standard in civil courts generally is 51%. If a jury concludes that you have proven something by what's called a preponderance of the evidence, they say, okay, that's a plaintiff's verdict. It doesn't get to 51%, defendant wins.
So what if it's not, I'm sorry.
Well,
these ideas of defamation, what if it's not actually going to a jury, but just an accusation when we're passing those thresholds to find out if it would go that far?
Oh, so each of those thresholds goes to the jury. And each of those thresholds has its own burden. I'm sorry, I know this sounds unduly complicated, but it's sort of a cascade of proofs. If you go over the first step, then you consider the second step. When you go over the second step, then you consider the third step. And as I described the different things that have to be proven, those are actually drawn from the model jury instructions that our Bar Association publishes, mostly. And so what I was describing is more or less each question that the jury answers. In an effort to make this even more confusing, there are certain steps within the steps that I described that have a higher standard of proof. One of them is malice. So I described all of those privileges that can sometimes apply to shield someone, whether it's talking about a public figure or common interest discussion or answering a question. Malice needs to be proven by what's called clear and convincing evidence. Now, I don't understand what clear and convincing evidence really means. We have three widely described standards. One is proof beyond a reasonable doubt. That's in the criminal courthouse. Preponderance of evidence. That's in most civil cases. Clear and convincing evidence is somewhere in between. But if someone authoritatively tells you they can make a bright line that shows you where one ends and the next begins, I don't think you should listen to that person. The judge will tell the jury, this is what clear and convincing means. And you have to believe that this evidence was clear and convincing. And the instruction from the judge is basically, well, did that clearly convince you? And obviously each individual juror has to make that decision. And they bring to the table all of their life experience and prejudice and common sense and frankly sometimes ignorance in their attempts to answer it. And the idea is that they all discuss it, and that what they conclude in that individual case is what's called the law of the case. And this, to loop back around to where I started, it can get confusing because I suspect we have our state's attorney here, and they try a lot of the same cases over and over again, and oftentimes it's the same fact pattern. There are a lot of domestic violence cases where the perpetrator says, well, I was just defending myself and that's why I did whatever. And I suspect that every state's attorney in every county in America has seen 10 to 20 of those cases and can tell a story of one case with almost identical evidence to another case tried before two different juries, where two different juries returned two different verdicts. I hate to tell you this because I could see why this would make a reasonable person uneasy. However, the difficulty determining what gets you over the border of the proof is the same reason I've never taken a plaintiff's defamation case. My firm has never taken a plaintiff's defamation case. The only time I'm ever aware of a plaintiff's defamation case being taken up by a lawyer in Brattleboro before this incident with the yoga studio was a case where someone at the American Legion said that a person in town was a murderer. The difficulty in defining the standard of proof is a double-edged sword. It's a two-way street. Lawyers in my position who sue other people only really do it if they're going to make money, and most of the time it's a contingency fee situation. We get a third of what we get. And so the difficulty that my explanation causes for someone who's saying, well, how can I tell whether or not I can prove that what I'm saying is true? It also applies to the question of, well, how can they show that what you're saying is false? And in the context we're here to discuss, accusations of sexual violence or sexual assault or sexual harassment or other such things. I think if someone who was accused of that came in and met with me, and this has not happened, this is purely hypothetical, I want to be very clear about that, but if they came in and met with me and they said, okay, so-and-so is accusing me of doing this, my first question to them would be, okay, why would they lie? And if there was not a good answer to that question, that would be the end of my analysis right there. Because I think that in a jury deliberation, I'm always trying to imagine what's going to happen in the jury deliberation. I think the first question any reasonably sophisticated juror who's been paying attention, it's likely going to be a he said, she said situation. Not going to be a lot of physical or forensic evidence in a case that has to do with allegations of something that happened in the past. There's usually not witnesses when it's sexually related. And so I think it's reasonable to conclude that most jurors' first questions can be, okay, he's saying this is completely false, but why would they lie about it? And I referenced an out of Vermont jury verdict of millions and millions of dollars. That was in a case that had to do with allegations of past misconduct. But there was a wealth of evidence supporting the fact that the allegations were false. There were witnesses from that time period who were aware of the relationship between these two people being completely different. And it seemed as though the proof of falsity was somewhat overwhelming. I could not find, and I did try, I couldn't find a case that was just person A says A, person B says B, the jury believed person A and awarded money damages.
Thank you. Kara, yeah, I'm going to ask. Wait, let's have Kara. So, Kara,
Very brief. I mean, all I would say is clearly defamation is really complicated. And I think it's a lot to take in and probably overwhelming for folks who are in the work. My former agency, the Center for Crime Victim Services, administers a grant to provide civil legal services for people who are, and again, the term of art is victims of crime, but that could be victimization that goes back pretty far. It's to address the civil legal challenges that arise from that experience, whether you've reported the crime or not. And I see someone from Legal Aid here. We give money to Legal Aid to support that work. There's a triage hotline, and you can go to, it's Legal Services of Vermont now, right? They've changed the name.
Vermont Law Help.
Vermont Law Help. So you can go online and access the portal there and call someone if you need help finding a lawyer. If nothing else, they can help you help yourself, but there's a whole cadre of lawyers all over Vermont who can help support you and help make a good referral if you need it, okay?
Hello. I made a complaint to a local town government about an individual who had sexually exploited myself and others as high school students. The town government responded by telling people who were involved in the commissions that I was concerned about to not give me any information about activities that were happening in the town, or whether there were policies to protect kids. Come to find out, there are no policies in this town to protect kids participating in town events. Anyways, I received a letter from the town, and in it they stated, while your correspondence and postings are veiled to appear that you are concerned about children's exposure to an alleged sexual predator, it is evident that your motivation is not to protect any child or children, but some other. Now, this has caused me a lot of difficulty because I experience a lot of social retaliation from individuals in this town government who are participating in town commissions, who are being instructed not to talk to me or give me information. I'm just wondering if I have any recourse. I feel like I'm being defamed by them stating that this is my intent when it is not. My only intent is the protection of children in that community. I'm just wondering if anyone has any suggestions in regard to this.
I just want to raise my hand and say I'm a witness to the other people who were abused too. I'm aware of her situation. She's got huge evidence, and there are lots of people affected.
Yeah.
Lots of people were affected.
Yeah, so I guess I would say, in New Hampshire, I have experience with this actually, and I can tell you a couple things. First, part of what you're doing right now is engaging in recourse, right? I mean, you're in the public forum, and you're describing in the public square, in a library, a deep concern you have about your government. And, and that is not in a court, but it is in the public space where you're attempting to affect public policy, which is a courageous thing to do. And a government effort to suppress that would be deeply troubling, probably would violate the First Amendment and may give rise to all sorts of litigation. The other thing to know is, and I deal with this, is governments are very hard to recover damages from because they assert things like immunity and it's hard to get a lawyer to take a case against the government because of that. And thoughtful attacks on state sovereignty are, though, nevertheless, I think, important. And I will defer to my colleague here about the extent to which Vermont courts are able to digest and allow people to move forward with those types of cases. My guess is it's harder to do.
So mixing in the fact that you have a municipal official complicates things because they're entitled to something called qualified immunity.
Right.
And I have sued both municipal officials and the state on a number of occasions. I can tell you that it's not something that absolutely bars lawyers from proceeding, but not only do they have a shield of qualified immunity, but they have guaranteed representation, which is, and I don't mean to suggest this is improper, but it's zealous. They'll have a deputy attorney general generally, or somebody working for the Vermont League of Cities and Towns in the case of municipal work, and those lawyers are highly competent, and their charge is to make it hard to sue a municipality so that only the most worthy claims actually recover anything. It usually takes years to go through it. That reality makes lawyers, though, very hesitant about taking claims against the town, and generally that manifests itself in people in my position saying, okay, was the person permanently injured, maimed? Because we work on contingency, it is a somewhat brutal mathematics where you say, okay, if I put in 1,000 hours for the next 2 or 3 years, am I going to be getting paid $10 an hour, or $100 an hour, or $0 an hour? I've had cases against the town of Brattleboro where we prosecuted them for 2 years and we lost, and that was just it, 1,000 hours down the drain. Not a fun experience to go through. The question of whether you can go after a town official for defamation in your individual circumstance, I think, hinges on publication. It sounds like the statement they made that you referred to was directly to you. If that is the case, that would be the hardest hurdle for you to get over.
But they've been instructing individuals on town commissions when I call and ask information not to speak to me. I don't know if they told them why. But,
so that,
yeah.
This could be an extraordinarily complicated conversation, but I'm going to try to distill it. They are going to say, well, that's us doing ordinary government business, and the qualified immunity applies to us doing our ordinary government business. I'm not saying that's true, but it's unlikely that there is going to be evidence that it's clearly false. It's one of those things that's very hard to prove false. So this is my way of saying it sounds like a very, very difficult thing to get recompense for, at least through the civil legal system.
I will add something. This problem is accentuated and exacerbated, in my experience, in the area of child protective services. It is amazing. The silencing that historically has gone on around calling out state officials for their deep dysfunctional failure to protect children is a well-known problem, and it creates all sorts of extreme levels of hypocrisy that should be deeply disturbing to everybody. It happens in New Hampshire. I'm sure it happens here. I'm sure that Vermont is a mandatory reporting state, and so, you know, the state is aware of all sorts of extremely troubling conduct vis-a-vis children, and it exists, as we've heard. It's deeply infused in our society, and it's important to continue to call out that misconduct. It's deeply important. And if anyone were ever to come forward and allege a defamation action against you for doing it, you have to, just like you need to remember, in my view, the first step is going to be to move to strike on First Amendment grounds, and, you know, to put the case in the position of potentially collecting attorney's fees under the statute you have. It is a very powerful free speech statute that accelerates the discussion about the protected aspects of the type of speech you've engaged in, and even may give you a remedy as a defendant in those types of circumstances. You've heard that there are some serious economic considerations that attorneys have to consider. One thing they don't want is to be on the receiving end of a response to a demand letter where you threaten their pocketbook when they're not even getting fees for the work they're doing for you. So they're thinking, I'm not even gonna put 1,000 hours in. I'm gonna end up in the hole because you know, my client is gonna owe attorney's fees for threatening this person's First Amendment rights. Make sense?
Makes sense. I just think I need to keep organizing in the community and getting advocates to address it that they can't individually target.
So before our next question, I just want to say one of the conversations that was woven throughout our vision for this event is to be keeping in mind the seeds for potential transformation of normative culture around all the secrecy around sexual violence, sexual harassment, sexual assault. So we're a mini think tank. This is one of what we hope will be a number of opportunities to really look at how we as community can transform this culture.
Okay, my question is a little bit more elaborated. It's not just, that was a good part of the question. Knowing that you've seen evidence of a person that has victimized others that are minors, and being a parent of children that are in a service type program to the public, not necessarily government program, but works closely with schools, the library, and seeing the evidence that that organization has possibly, I don't want to say definitely, but right now it's looking more possibly that they have covered and protected a possible predator. I guess my concern is not really in hopes being completely in poverty, and I would never be able to defend myself in court by getting a lawyer. There's just no way unless the ACLU visits me free. I would have to defend myself on that board and hope I can make it to the court. Where is like my legal standing, for one, not being able to ever pay for a lawyer, for two, against an organization that I have chosen to speak out about because I've been hitting brick walls and been given constant lies on timeline. I'm not the direct victim, but I have seen direct evidence. I don't know. It's kind of an elaborate question, but.
So it's two-part.
Yeah.
Best solution, if there's somebody who's actually been injured, is to get that person to a lawyer. For all the negative things about society that personal injury lawyers may cause or be perceived to cause, and I do personal injury work too, if somebody came to me and said, my child was sexually molested.
Well, my child wasn't.
No, I understand. That's why I'm saying.
The risk was there.
In my view, the thing that is good about personal injury lawyers is that most organizations don't want to get sued. And most organizations recognize that when they do get sued, it's really unfun and sometimes leads to their ceasing to exist. And I think the simplest solution is, if you're aware of that sort of thing, you should try to reach out to victims and make sure that they realize that they would have access to a lawyer that they didn't have to pay a dime to, because a reasonably competent personal injury lawyer is going to say, oh my God, let's start this lawsuit tomorrow. Here's the papers. You don't have to pay me a dime. But to answer your question a bit better, you mentioned that you don't have a lot of money. And people here, no, that's okay. But people here should be aware that any assets you hold jointly, whether marriage or otherwise, are exempt from judgment. That means if somebody gets $1 million judgment against you, it doesn't matter. Your equity in your home up to $125,000 in Vermont is exempt. Your car up to $7,000. There's a few other things. It's like a horse and a few chickens. This is law that also goes back to the 1700s. And so I think that it's perfectly reasonable for people to be worried about being sued for defamation and anything else for that matter. However, if you wanted to say publicly that you are concerned that this institution is not protecting its children, first of all, that's a matter of public concern, which Mike probably knows more about than me, but that entitles you to the higher level of protection where they would have to prove malice on your part, and that's the thing that they have to prove by clear and convincing evidence. I hate clear and convincing evidence. If it's not clear and convincing to you, I'll just say it.
I'm not aware and I hate it.
It just makes no sense to me. But it creates a level of protection for you that is as high as it can get in this little section of the legal pie. And most institutions have institutional counsel from larger law firms. Those institutional counsel, I think, are generally more careful. And I mean that in a good way. And my view is that an institution would be less likely to be aggressive towards you than an individual who felt offended or embarrassed by allegations. Moreover, that institution would likely have to pay their larger law firm lawyer on an hourly basis to do that. And that can be anywhere from $300 to $600 to $700 an hour. That's a good business to be in, representing daycares, hospitals, etc. And I think there are a lot of both tangible and intangible motivating forces that militate against them being aggressive toward you.
I wanted to add,
Yeah, go ahead.
I guess I have two questions. Well, I'll just stick to the one situation. I was abused quite a bit as a child, and in one situation it was with my uncle. And it precipitated my father's suicide as well, 12 years later. And, or it was part of the factors in there. And my sister and I still want to confront him. But we don't necessarily want to go through a legal process to do that. So is there, and this is addressing your concern as well, your story. There are so many people that are abused by family members. There's no system. There's no way in which to have some kind of reparation. Whether it's monetary or not doesn't matter. It's just some reparation in our society for these harms done within the family system. And I'm just putting it out there. Does anybody have ideas?
Thank you.
First of all, I'm
so sorry that happened to you and in your family, and hear you wanting to be able to somehow confront that behavior and the lack of options to do that. And like I said earlier, as community justice centers in Vermont at this time, it's not something we can do, but there are organizations out there that have some resources. Unfortunately, they're not close, but I just want to recommend looking into this organization called Generation 5, and their goal is to end childhood sexual abuse within 5 generations, and they use restorative and transformative justice principles to do that, and an organization called Creative Interventions that does similar stuff. I'd be happy to talk to you more later if you're interested in learning about some resources, even if they're not local, to at least maybe you can talk to someone or start thinking about it. So I just want to put that out there.
Well,
Can I just respond to that? No, I'm sorry.
I just wanted to follow up. So I volunteered at the BCJC for 11 years, and I love that we're in a circle. And I've learned that there are lots of ways of using restorative practices to, I would say, reparations. I mean, I don't understand exactly what reparations would be in this case, except better understanding, or I guess, so I didn't know about these resources, but I know that discussions, and obviously they would have to be safe, they would, and what we know about restorative justice is people have to be willing to participate, which is possibly unlikely. But humans are about relationships and stories. And so if nothing else, telling your story is a first step, and just minding our relationships all the time is maybe the next.
And I also, Cara, I wonder if you have anything to add as well to the restorative justice piece. I'm also wondering if state level advocates are able to facilitate those kinds of conversations, victim offender dialogues, or not ever with this kind of case.
Yeah, I can't think of resources in Vermont other than, I mean, I think it's great that there are some other outside resources. I mean, I think more generally too, it's really important to do some deep work with a therapist, with your family, with advocates, to really think about what your expectations are, and what you hope to expect from whatever it is, whatever systems or processes, because I think one of the toughest things about systems because there's lots of them actually, is that sometimes we come to systems with expectations that can't be fulfilled, or there's a lot of systems. There's opportunities. I used to be a plaintiff's attorney myself. There are opportunities if part of your expectation is that you get your therapy bills recovered. There's an opportunity to bring a civil lawsuit against somebody to, recover the cost of your therapy bills. Not everyone's expecting that. I'm not hearing that's something that you expect. But maybe that is something you expect, and so you want to be approaching the right system with the right people to be able to do that. By and large, if part of your expectation is to make sure that somebody isn't going to be able to work with children again, then there are some state systems that need to be brought into play, because that can't happen without that individual being entitled to due process, right? So there's DCF has process, right? The criminal justice system has process, and if that's your expectation, that's the only place you're going to be able to go to get that, right? So I think that's the other thing too, to really sort of explore, is like what are your expectations. And again, though, I would say the speaking out is so powerful, because it goes back to, I think, something Donna had said, is the blur between the law and our society, and the interplay between those two things. If we want to advance the law, if we want juries who will trust us and believe us and listen to us, then we have to be telling our stories and doing the work to advance our society.
Thank you.
And I just want to say we have about 5 minutes. I feel like this conversation could continue, but I want to make sure we get
Thanks.
this.
So I just wanted to say that you were talking about expectations and systems and supporting. And I work with, for a long time as a clinician, with people who have experienced, you're very experienced, and others. And the expectations that I find that I think is really important is, what are your expectations aside from systems? What is it you want from your uncle, you and your sister? What do you expect that he will say to you? And what does that mean? Some people will say, well, I want him to apologize. Well, then, so you will then know that you are a wonderful person and it had nothing to do with you. Well, I don't know. I'm just saying it's really important to get the support you need. If you're not going to do it within a system and you and your sister want to, it's what you're going to need, not depending on what he tells your response to. There you go. Yeah.
My sister without doing that work. So.
Can I comment on that really quickly? I've had a case with a victim of a rape who said, we went to mediation. All civil cases have to go to mediation with very few exceptions. And at the mediation, which was conducted with the two parties separate, never seeing each other, we said, well, here's how much we want, and here's how much we want if you apologize in writing. They chose the second option. I don't know if that would help you, and I think there are a lot of people it would not be helpful to, and I actually just had contact with this person, and they were having second thoughts about that process. It did not do for them what they expected it would do.
I think that what victims want the most in many ways is for the perpetrator to know how much damage they did.
True. I agree.
Well, what you said, though, reminded me of something I wanted to mention that is not related directly to your question, but there has been historically a statute of limitations that would have prevented a lot of people who have long ago sexual trauma from suing the perpetrators. And the legislature is considering removing that entirely this year. No more statute of limitations. The civil system is an awful system, whether somebody dies, whether somebody is hurt. No amount of money, generally the worse whatever you're trying to compensate is, the kind of less it helps, even though it's more money that you're entitled to. However, I'm hopeful that there will be more cases generally that then get into the news that establish that this is something that, if you do it, subjects you to liability for hundreds of thousands of dollars for the rest of your life from the perpetrator's perspective.
And it's curious to me that I've only seen large amounts to men who've been abused. I don't ever see that for women, which is not to comment on the fact that it happens to both men and women.
Right. Thank you. So we are going to bring things to a wrap.
Yeah.
I just want to say, as a almost 30-year advocate at the Women's Freedom Center, when I look around this room, there have been a lot of people who haven't spoken into the mic tonight, but I want to say, as an advocate for sexual and domestic violence, we are really privileged to live in a community that deeply, deeply cares about survivors of all kinds of violence. And so in the room tonight is a state's attorney who cares about and prosecutes fiercely and really aims for accountability, amazing victims advocates, a representative and an awesome longtime attorney from Vermont Legal Aid, a woman who listens to stories of sexual assault and violation every day, who works at Windham County Safe Space. So even though these folks haven't, been asked to step up to the mic, they're in this circle, they're here and present, they're listening, and I just feel like for any of you who may be sitting with a decision about how to move forward with lived experience, I think it's helpful to know that you live in a community that is really present and wanting to hear what you need and what you have to say.
And I just also did want to say to the survivors in the room that if you feel compelled in some way to bring your story forward, whether, and then many people decide not to, and I don't want to imply any judgment, but that I found it so powerful after the Kavanaugh hearings in a similar way, even though a very different situation from Deb, to decide that I'm going to write about this because that's my medium, but for you it could be speaking out, and to be able to tell your story as it happened and to be believed as one of the more healing and cathartic experiences that I've had. Much, I'll have to say for me personally, like much more valuable than many years of therapy. So I guess I want to urge, and if anyone, I don't work in any kind of professional capacity, but if anyone wants to speak to me about what it means to write your story and to bring it forward, and we've heard from the legal professionals that there is a lot of protection for that in the system. So, yeah.
Thanks. I was going to say something very similar. When the Women's Action Team first got going, one of the things that happened was folks went up to Montpelier to hear representatives from Planned Parenthood speak. Planned Parenthood said, we just don't have resources developed enough to speak publicly about what we need to accomplish politically. And we said, okay, that's what we're going to work on. And Willow, who you met at the beginning, who's the filmmaker, encouraged us to sit in front of a camera and tell our stories. Likewise, I've been in therapy since I was 22. I'm 54. Nothing has been as therapeutic for me as taking part in that process and being enabled and supported to speak my story and be held in community. It was amazing. So this is my motivation for being here. I want to thank everyone for holding this conversation so beautifully. Clearly there's more that needs to be said, much more. And I think we found some really interesting areas to look at and consider further. I want to be sure that you've had a chance to sign up for any follow-up information from this #MeToo team and the collaborating process that we're involved in with the Women's Freedom Center. I can't promise what the follow-up looks like yet, but we will have some kind of follow-up. We also send out an occasional newsletter. So thank you again, and thank you to Star, the spectacular librarian who has transformed this space into a public gem.
I love this community, and I love you for bringing this wonderful opportunity.
How incredible is this? A few years ago, this was unimaginable, and here we are doing this. I want to, just speak to the generosity of our guest speakers. We're all so lucky to be so much more informed right now. Sometimes we act on our idea of what's legal. People talk about what's legal all day long without knowing, and people act on that idea. It's such a privilege to actually sit down and get the nitty-gritty of it to a degree, and really be more informed as citizens. And we can take that information to people we know. We can take this information into our community and empower each other. And that's the goal. Have I left anything out? Okay. Thank you so much.
Thank you.
When you see the